Judge Payson?
Okay. Yes, I'm ready.
Thank you. This is United States of America versus Dominic Pezzola, 21 MJ 4007.
Okay, good afternoon. My name is Judge Payson. I'll be presiding over this initial appearance. Let me just confirm first with Mr. Shibetta of his understanding that Mr. Pezzola is consenting to appear by video.
Good afternoon, Judge. Nice to see everybody. Yes, we have had that conversation, and he is consenting to appear in this fashion.
Okay, Mr. Pezzola, are you consenting to appear by video for this initial appearance?
Yes, ma'am.
Okay, very good. Let me also indicate that there is an official recording that is being made of the initial appearance, but pursuant to the court's rules, no one else may record the proceedings, and any recording is strictly prohibited. All right, so Mr. Shibetta, I want to confirm with you that you have received a copy of the criminal complaint filed against Dominic Pezzola, as well as a copy of the arrest warrant.
Affirmative to both, Judge. Kathy sent those over to me via email.
Okay, and you're satisfied with the copies that you've received of those documents?
As far as them being legible and of good quality, yes, Judge.
Okay, you're not asking for certified copies of the documents?
No, I'm not.
You're ready to proceed on the documents you have?
Yes.
Okay. All right. So the purpose of the proceeding today is to advise Mr. Pezzola of the charges against him, the maximum penalties that he faces, the rights that he has in connection with those charges, and then to set a next date for a court appearance, be it here in this district, the Western District of New York, or the District of Prosecution. So let me first indicate that my understanding is that Mr. Pezzola surrendered himself this morning in connection with the criminal complaint. Mr. Harvey, can you affirm that that's the case?
Yes, Judge, I can confirm that's the case.
Okay, and specifically the complaint that I'm referring to is a complaint that was issued in the District of Columbia on January 13th, 2021, and there was an arrest warrant that was issued in connection with that criminal complaint. The criminal complaint charges Mr. Pezzola with violations of three statutes, specifically a violation of Title 18 United States Code, Section 1512C2, obstruction of a criminal proceeding. As to that particular offense, the criminal complaint charges that on or about January 6, 2021, in the District of Columbia, that Mr. Pezzola corruptly obstructed, influenced, or impeded an official proceeding or attempted to do so in violation of 18 U.S.C. Section 1512, subsection C2. Before I move on to the other crimes with which he is charged, Mr. Harvey, what are the maximum penalties that would apply in the event that Mr. Pezzola was found to have committed that offense?
Judge, up to 20 years imprisonment, a $250,000 fine, 3-year term of supervised release, and a $100 special assessment.
Okay, and the criminal complaint also charges Mr. Pezzola with violating Title 18 United States Code, Section 1361, on or about January 6, 2021. As to that statute, the criminal complaint charges that on January 6, 2021, Mr. Pezzola willfully injured or committed a depredation against property of the United States or attempted to do so. If Mr. Pezzola were to be convicted of that charge, what are the maximum penalties that he would face?
Your Honor, that section charges or includes both a misdemeanor and felony level offense. For the felony level offense, which is, I believe, is supported by the affidavit, the maximum penalties would be 10 years imprisonment, a $250,000 fine, 3 years of supervised release, and a $100 special assessment.
And whether it is a felony or misdemeanor, it depends on the value of the property at issue, correct?
Yes, that's correct, Judge.
Okay. All right. And finally, the complaint charges that Mr. Pezzola has violated Title 18 United States Code, Section 1752A, which deals with restricted building or grounds. And specifically, Mr. Harvey, what are the subsections of the A with which Mr. Pezzola is being charged?
Your Honor, he is being charged with 1752 subsection A, 1, 2, and 4, all as misdemeanors.
Okay. And you say they are all misdemeanors?
At this stage, yes, that's right.
Okay. Meaning that the maximum penalties are?
The maximum penalties are 1 year imprisonment, a $100,000 fine, 1 year term of supervised release, and a $50 special assessment.
Mr. Pezzola, let me enumerate for you the specific subsections under which you are being charged. 1752A1 prohibits the knowing entering and remaining in any restricted building or grounds without lawful authority to be there. 1752A2 prohibits knowingly and with intent to impede and disrupt the orderly conduct of government business or official functions, engaging in orderly or disruptive conduct in any restricted building or grounds when that conduct does in fact impede, disrupt the orderly conduct of government business or official functions. And Section 4 prohibits the knowing engagement in an act of physical violence against any person or property in any restricted building or grounds. The criminal complaint is accompanied by an affidavit. The affidavit is 10 pages long, and the affidavit sets forth the factual allegations in support of the charges against Mr. Pezzola. Mr. Pezzola, you have important rights in connection with the charges pending against you. First, you have the right to the assistance of an attorney. If you can't afford an attorney, you have the right to ask the court to appoint a lawyer for you. Now, my understanding is, Mr. Shibetta, you have been retained by Mr. Pezzola to represent him in this district?
That is correct, Your Honor.
Okay, and Mr. Pezzola, you'd like to be represented by Mr. Shibetta?
Yes, ma'am.
Okay. You also have the right to remain silent. You must remember that anything that you say may be used against you. If you've begun talking to law enforcement agents or prosecutors, you don't need to continue those conversations. If you choose to have them, you have the right to have your attorney present with you during those discussions or any interrogations. In addition, you have the right to a preliminary hearing. Preliminary hearing is not a trial. That would take place further down the road. A preliminary hearing is a court proceeding in which a judge determines if there's probable cause to believe that you've committed the offenses that you're charged with. If you're held in custody, you have the right to a preliminary hearing within 14 days. If you're released on bail, you have the right to a preliminary hearing within 21 days. You have the right to be released on a reasonable bail unless the court finds after holding a hearing that there are no conditions or combination of conditions which would reasonably assure your return to court and the safety of the community. Now, because you have turned yourself in a district other than the district of prosecution, you have two additional rights in addition to the rights that I've gone over with you. The first is a right to an identity hearing. You have the right to a hearing at which the government would have to establish that you are the same Dominic Pezzola for whom the arrest warrant issued on the complaint that I've described to you that's been issued in the District of Columbia. That would be the government's burden of proof, and you have the right to have that hearing in the Western District of New York, where you've surrendered on the charges. If you choose to waive that hearing, you do not have the right to have that hearing in the District of Columbia. And finally, you have the right under Federal Rule of Criminal Procedure 20 to have the prosecution against you transferred from the District of Columbia to the Western District of New York provided that you state in writing a wish to plead guilty or nolo contendere and to waive trial in the district of prosecution, that you consent to the disposition of the case in this district, that you file that statement in this district, and the United States attorneys for both the Western District of New York and the District of Columbia approve of the transfer of the prosecution from the District of Columbia to the Western District of New York. Mr. Pezzola, do you understand those rights?
Yes, ma'am.
Okay. All right. Mr. Harvey, what about the government's position with respect to release or detention?
Your Honor, the government moves to detain the defendant on the grounds of both risk of flight and risk of danger to the community.
Okay. Mr. Shibetta, have you had a chance to discuss with Mr. Pezzola whether he wishes to go forward with a bail hearing in this district or in the District of Columbia?
I have had that conversation, Judge. He is agreeable to having that matter decided in the District of Columbia Court.
Okay. And is that accurate, Mr. Pezzola?
Yes, ma'am.
Okay. So you'd like to have that hearing in the District of Columbia?
Yeah, that's what my lawyer advised, so I'm going off his advice, yeah.
Okay. All right. And how about an identity hearing, Mr. Shibetta?
We're going to waive that.
Okay. Mr. Pezzola, I just want to make sure that you understand what we're talking about here. As I explained, that's a hearing at which you have the right to contest if you wanted to, that you're the person who is named in the complaint and for whom the arrest warrant issued. You have the right to have that hearing here. And you also have the right, if you wish, to waive or give up your right to an identity hearing. Mr. Shibetta has said that you are waiving, that is giving up your right to an identity hearing. Is that accurate?
Yes, ma'am.
Okay. Did anybody threaten you or coerce you in order to get you to give up your right to that hearing?
No, ma'am.
Okay. Anybody make you any promises in order to get you to give up that hearing?
No, ma'am.
Okay. You making that decision voluntarily and intelligently?
Yes, ma'am.
Okay. All right. Well, I will accept Mr. Pezzola's waiver of the identity hearing and find that his waiver is knowing and intelligent. Now, with respect to the detention hearing, what is going to happen then is that Mr. Pezzola will be transported to the District of Columbia, where the hearing will take place, and a date will be set at that time for further proceedings in the prosecution, as well as a date set for a preliminary hearing. Mr. Shibetta, is there anything else? Or oh, I'm sorry. Let me issue the Brady advisement that I'm required to do. Mr. Pezzola, as required by the Due Process Protections Act and Federal Rule of Criminal Procedure 5F1, the court confirms the United States' obligation to produce all exculpatory evidence to the defendant pursuant to Brady versus Maryland and its progeny, and orders it to do so. The government must make these disclosures in sufficient time that the defendant will have reasonable opportunity to act upon the information efficaciously. United States versus Rodriguez, Lica versus Portnando, United States versus Coppa. Failure to do so may result in consequences, including but not limited to exclusion of evidence, adverse jury instructions, dismissal of charges, contempt proceedings, or sanctions by the court. Mr. Harvey, did you elucidate the bases of the motion for detention?
Yes, I said both risk of flight and risk of danger, Judge.
Okay, all right, so both prongs. All right. Mr. Shibetta, is there anything else that we need to address today?
Judge, this may not be a question you can answer. It would be in the province of the marshals, I suppose, but do we have any idea of when he will be transported down to DC?
Well, you're correct that I don't have that information. Mr. Harvey, I don't know if you have any further information on that.
I do not have anything on that, Judge. I know that they will move with due speed to get him down there, but I don't know what the time frame is.
Okay. Anything else, Mr. Shibetta?
Yeah, it just if Brett, Mr. Harvey, if you could just advise me if you do hear when that's going to transpire.
Absolutely, will do.
Thank you. Nothing further.
And Judge,
Mr. Harvey, anything else?
yes, Your Honor. Very, very quickly, just a housekeeping detail. I've spoken with my colleague in the District of Columbia, and he asked me to correct the record on one small point. The affidavit in paragraph 13 indicates that the breach involving a breach of the Capitol involving this defendant occurred at approximately 2:39 p.m. That was based on a timestamp on some video footage. And that is an accurate summary of what the timestamp said. However, based on other photographic and video evidence that depicts this defendant inside the Capitol and the timestamps that are associated with that new footage and other evidence collected in the course of the investigation, the FBI now believes that the 239 timestamp may not accurately reflect the time of the actual breach. They are still gathering evidence and trying to establish a definitive timeline, but I wanted to let the court know that for purposes of the record.
Do you know whether the FBI believes the timestamp is earlier than the breach or later than the actual breach?
They did not say, Judge. They indicated that they don't think it's necessarily accurate, but they're trying to get a handle on that.
Okay.
But like I said, it is an accurate. It's accurate in the sense that it summarized accurately what the timestamp said, but they're just questioning whether the timestamp is accurate.
Okay, but you are representing that it occurred on the afternoon of January 6, 2021.
Yes, that's correct, Your Honor.
Okay. All right. Anything else, Mr. Harvey?
Nothing further, Your Honor. Thank you.
Okay. Mr. Shibetta, anything else?
No, Judge, thank you. Nothing further.
Okay. All right. Thank you very much. I wish everybody a nice day.
Thank you.
Bye-bye.
You too, Judge.